Mr. Willis, Mr. Mould, I do apologise. The delay is entirely my fault, nobody else's, and I apologise for it. I'm sorry.
Not at all. We've been helpful. We've been able to chat about old times.
Now look, might I just say, I appreciate that everybody always wants to finish sooner than the time estimate allows.
Yes.
But just lest there be any concern, because I appreciate that Mr. Miller still has a lot to go. Even if I were to stand up a little later than he said,
yes,
I foresee no difficulty in
fine.
concluding well within the day-and-a-half time estimate.
Well, that's very helpful, Mr. Mould. And certainly, as I'm sure you both recognise, there has never been any intention to create pressure or the impression of pressure. So please do not feel under any pressure whatsoever. And what Mr. Mould has said is, of course, well received here. So
thank you.
I hope that helps, Mr. Willis.
It does. Thank you, my lords, and thank you, Mr. Mould.
Thank you. Yes.
Before going back to ensuring fairness in the planning system and the evidence of Mr. Gallagher, can I just make one point, perhaps an overarching point, about submissions which were made by the interveners? Your lordships will have their skeleton argument or submissions, written submissions, in the core bundle 117 onwards, and I just wanted to indicate that the appellant gratefully adopts those submissions insofar as they touch on grounds 2 and 8 and more generally in relation to the impacts that the definition change has on gypsies and travellers. But also going back to the point about traditions, the interveners helpfully quote from the decision of the decision of the CRE against Dutton, which was the case in the Court of Appeal where it was decided that Romany gypsies should be entitled to, well, are a separate ethnic group. And in paragraph 36 of the intervener's skeleton argument, there's a quote from Lord Justice Nichols relating to the factors that led the Court of Appeal to conclude that they were entitled to ethnic minority status.
Yes.
And perhaps if I can just read it, my lord. It says this.
Do you want us to look at?
Yeah, if you don't mind, page 126 of the core bundle,
Right.
paragraph 36.
Yes.
On the evidence, said Lord Justice Nichols, it's clear that such gypsies are a minority with a long shared history and common geographical origin. There are people who originated in northern India. They migrated thence to Europe through Persia in medieval times. They've certain, albeit limited, customs of their own regarding cooking and the manner of washing. They have a distinctive traditional style of dressing with heavy jewellery worn by women, although this dress is not worn all the time. They also furnish their caravans in a distinctive manner. They have a language or dialect known as Pogody Chib, spoken by English gypsies, Romany Charles, and Welsh gypsies, Cale, which consists of up to 1/5 of Romany words in place of English words. They do not have a common religion nor peculiar common literature of their own, but they have a repertoire of folk tales and music passed on from one generation to the next. No doubt, after all the centuries which have passed since the first gypsies left Punjab, gypsies are no longer derived from what in biological terms is a common racial stock, but that of itself does not prevent them from being a racial group as widely defined in the Acts. There is also a reference, my lord, to the Clark case in paragraph 40, and just as a reminder to myself, but to indicate to the court, we're in the process of obtaining the Court of Appeal's judgment in the Clark case.
Oh, yes.
I having indicated that the Court of Appeal endorsed the Chapman judgment, and certainly paragraph 73 of that judgment and the reference to living in caravans being an integral part of the gypsy way of life. My lord, back to the evidence which was put before the court by the respondent and Mr. Gallagher's witness statement, which we found in the supplementary bundle, but more importantly, the public sector equality duty analysis, which dates back to January of 2015. We've looked at the email which attached the analysis at page 143, and then I took you to page 151, where we see, under the heading Ensuring Fairness in the Planning System, the amended planning definition being the proposal, the objective to ensure the planning system applies fairly to all. And then one can see that objective being amplified or explained in the text below the reference to section 149 of the Equality Act in bold. And indeed the recognition on the part of the respondent that this proposal will have an impact on the identified racial group, i.e. Gypsies and Travellers, which rather harks back to ground 2 of our grounds of appeal. It says, we note, for example, that Romany Gypsies and Irish Travellers are a protected race under the Equality Act. Additionally, within this group, there's likely to be a specific impact on the elderly, disabled and possibly women, particularly those from single-parent families. We recognise that age, disability and gender are also protected characteristics under this Act. And then one of the impacts identified in the next paragraph was that the definition change could mean that those persons without family connections will no longer be able to live with other members of their Gypsy and Traveller community. And turning over the page under the heading Balancing Exercise and Alternative Options.
This is on page...
page 15. I'm going to take you to page 152 if I may, but it begins at the bottom of page 151.
Yeah.
And forgive me, I'm not going to read out the whole of the text, but my learned friend might want you to be referred to parts which I don't read. 4 lines down from the top, the text reads, overall it's important for this government to implement a fair planning system for all, and that where Gypsies and Travellers have settled permanently, they should be treated no differently to the rest of the settled community for planning purposes. That, we say, is significant. It's an explanation for the definition change, and indeed it's a recurring theme in the remainder of the contemporaneous documentation, which I'm going to take you through very briefly. The next paragraph deals with, in that very same top paragraph, there's a reference to evidence. Evidence in the form of 4 lines from the bottom of that paragraph. Evidence in the form of departmental correspondence and supported by responses to the consultation raises concerns about fairness in the treatment of planning applications for travellers who have ceased to travel, yet are still defined as travellers under the planning policy. On balance, the interference is proportionate. And then a recognition that when implementing the new definition, there will remain a need to consider Article 8 in the best interests of the child. Obviously, that wouldn't necessarily apply to elderly Gypsies and Travellers, but Article 8 considerations would. And it said, therefore, the impact of the change is likely to be focused on a small group. In cases involving families and some members, where some members do not travel, it may continue to be appropriate to grant travelling planning permission. Sorry, I'm not reading this very well. To grant permission for traveller sites on the grounds that it is proportionate to do so and would be an unlawful interference with human rights to limit the permission to particular family members only. As such, we consider that the group of persons most likely to be affected by this change are quite small: elderly, disabled and possibly women, particularly those from single-parent families without family connections. And then there's a recognition in the next paragraph that there is a risk of homelessness, unauthorised camping, including roadside camping, a risk that may increase as Gypsies and Travellers may try to ensure that they fulfil the new definition by demonstrating that they have not permanently ceased to travel. This may impact on their ability to access services such as education and health, and would impact on Gypsies and Travellers, particularly the elderly, disabled and women. Such risks will be kept under review. There's no evidence, by the way, that there's been any review of the impact of the definition before this court. And then
just going back to the first hole punch,
yes,
in cases involving families where some members do not travel, it may continue to be appropriate to grant permission for traveller sites on the grounds that it's proportionate to do so, and would be an unlawful interference with human rights to limit the permission to particular family members only. But that, of course, doesn't find its way into the policy.
no,
And if it's the current definition that defines who can or cannot live in a particular site, then that, as it were, balancing factor doesn't find any expression anywhere.
it certainly doesn't expressly in the policy. And we've got an example where it clearly wasn't applied, that being the case of Charmaine Valor. That's not to say that in an individual case, an inspector might be perhaps persuaded
Yes.
that planning permission should extend to the whole of the family, even though some of them do not
Quite.
comply with the definition.
But that would then be, well, that would then just demonstrate this is not an ab ante challenge,
Yeah,
but is a particular challenge.
my lord, yes.
But the point is that balancing factor, it may be appropriate, whatever, isn't in the policy.
No, my lord, that's right. In fact, if one looks at the policy, PPTS 2015, there are some changes made to it, which are reflected in the recommendations which we saw in at page 143 in the email. And some of those have changed by the time the policy was amended. But there's nothing in the policy by way of mitigation or a safety valve for those who may be members of a family where some members travel and some don't. I mean, what is perhaps significant is that there's no, as it were, attempt to rebalance or rejig the policy in PPTS as a consequence of the policy definition change, in order to ensure that non-PPTS gypsies and travellers have their needs properly addressed. And then if we look elsewhere, we see that the Equality and Human Rights Commission review shows that the attempts to address those needs are very patchy and are not helped by the fact that there's no guidance issued to local authorities on how to go about that process. But the other point to make about the first hole punch paragraph, my lord, is this there's a conclusion that the group of persons most likely to be affected by this change are quite small. Now, in terms of those who might be affected, the elderly, disabled and possibly women.
Sorry, forgive me, you're reading now from...
Sorry, page 152.
Back to 152.
Back to 152,
Yeah.
Apologies.
That's right.
That same paragraph that we were discussing. It's a conclusion that the group of persons most likely to be affected by this change are quite small, when in fact, what we can see when one looks at the impacts of the definition from the evidence we have before this court, the impact is far from small, or quite small. It's significant. One only has to look at the Equality and Human Rights Commission report to see that. But one knows that it's not just about plan making and the assessment of need, but also this definition, if properly applied, will mean that there may be any number of gypsies and travellers who will fall foul of planning enforcement because they no longer travel for an economic purpose and can't comply with the condition attached to the planning permission for a site which they may have lawfully been granted permission.
That second sentence, the quite small, and I also note without family connections, is a result of the sentence I drew your attention to, because it says as such. So if the potential watering down doesn't appear in the policy, then nobody could necessarily say, could they, whether it would be quite small, and certainly whether they would be without family connections.
No, that's right, my lord. And that is, perhaps going back to my point, only consider that only relates to the position on individual planning applications.
That means, yes, there may be some ambiguity in that sentence. I'm not sure. The group of persons most likely to be affected by this change are quite small, without family connections.
I suppose the words "as such," my lord, are key. Are they not?
Yeah.
Because that links that sentence with the previous sentence, and the assessment of impact in this paragraph seems to be, or at least in this sentence, which begins as such, seems to relate to those who can't necessarily say to an inspector or a local authority when applying for planning permission, well, I may not be travelling, but my son and daughter are, and they look after me and care for me, and we should be entitled to remain on a site.
It either means, or does it mean that if you leave out those who are in the category that goes before that, referred to in the sentence that goes before that sentence, the residual category is quite small. In other words, if you apply the policy with that caveat, not written into the policy, as has been pointed out, but if you apply the policy with that caveat, the residual cohort is actually quite a small cohort. Is that what it means?
I think the problem with that
was it the opposite?
Well, I don't know, but the problem with the
it's not for you to explain ultimately.
No, my lord. But I suppose that the words in parenthesis make me think that actually best interest of the child and Article 8 may apply to those single parent families.
That's right. That's right.
So it's difficult to resolve the ambiguity. I suppose my overarching point here is that the only impact that is being considered in this document, and indeed the other documents which I'm going to take you to very briefly, it is the impact on gypsies and travellers who are elderly and or disabled, no longer travel, and are seeking planning permission for their own sites. No consideration of what might happen to those living on authorised sites with the condition attached requiring compliance with the definition, those on rental sites with the same requirement, or indeed the assessment of the needs of gypsies and travellers, and the significant, as we've seen, impact that the change in the definition has had. And in the absence of any assessment, let alone any proper assessment of those impacts, the respondents' approach, indeed its attempt to justify the discriminatory impact, is fundamentally flawed.
So you pay particular attention, is this right, to 151 to 153, because that's dealing with the measure that you say this case is all about.
Exactly, my lord. Rather than the approach taken by the learned judge in the court below,
which is looking at the policy overall.
Look at the policy as a whole.
So is there anything else you want to take us to in particular on the if you're right that all we're concerned about, or specifically concerned about, is the measure? Is there anything else in
Well, only this, my lord. If one turns to the later public sector equality duty analysis, which is attached to an email which you'll find at page 175. The pagination is in the middle of the page.
Thank you.
Sent on the 23rd of June 2015. And then the public sector equality duty analysis begins at page 180. You'll see, and I haven't checked it, it is exactly the same, but much the same reasoning, with an objective stated to be the objective of the measure to ensure that the planning system applies fairly to all.
Just to take up a different matter, if I may, Mr. Williams,
Yes.
but just looking at this later document, it appears to be the same as we saw on page 151.
Yes.
I'd just like your help on this, please. In this document, middle of page 181, in bold 3, section 149 considerations,
Yes.
and 3 of them are identified. And then the first non-bold paragraph seems to say that the proposal doesn't further any of those desirable aims, including that it doesn't foster good relations between persons who share a relevant protected characteristic and persons who do not. And yet, both in this document and the earlier iteration, here at the very foot of page 181, the last line, the proposal will also support the government's aim of reducing tensions between the traveller community and the settled community. I wonder if you can assist with that, because speaking for myself, I can't immediately see how something which avowedly does nothing to foster good relations nonetheless achieves that aim. Unless I've missed a negative somewhere which perhaps transforms the whole meaning.
You haven't missed a negative, my lord, as far as I can see from that top paragraph after the section is set out. I can't explain the ambiguity. I can see that the minister and perhaps his civil servants saw the merit in addressing concerns raised in the consultation process about a perception of unfairness, and that by, as it were, restricting the definition, that might satisfy some of those concerns. But there it is, bold as brass. Does not foster good relations, I think that should read, between those who do.
Well, it does, and exactly the same typo occurs in the previous version, so this part of it, at any rate, is simply copied and pasted.
Yeah. I mean,
So
there's a.
what do we? It's connected, so I'll ask it if I may, rather than
Certainly.
wait. We find the words again to ensure that the planning system applies fairly to all, and then we find a little further down under 4, balancing exercise and alternative options. This definition change meets the legitimate policy objective of achieving fairness in the planning system. And then a fair planning system for all. If we want to find out how this fairness consideration is meant, we have to look at these following paragraphs. Do we?
We do, Mona. We don't have any other reference. For example, there's no evidence
How
identifying the consultation responses.
well, the long and short of it is, how is fairness achieved in the planning system? Does it say? Not merely unfairness avoided, but fairness achieved. How is that explained?
My lord, I think that's going to be a question for Mr. Mould. I really don't have an inkling. What? Sorry.
I obviously would expect to deal with that when I respond, but I mean, I can give you a page reference now if it would be helpful. I don't want to interrupt my learned friend if
I think it would. I think, for my part, it would be helpful just
Yes.
to have that, so that Mr. Willis can deal with it now, and then you know what he said about it.
Yes. The 2014 document that he took you to, which I think was at page 151, 153 thereabouts, that document was a public sector equality duty analysis that was carried out in the course of preparing a consultation document. And the consultation document is at page 205 in the supplementary bundle. That consultation was carried out in late summer and autumn 2014. And you'll see that at page 212 to 214, chapter 2 of the consultation document sets out the government's proposed change to the definition of which was in the then current PPTS 2012, and in the following paragraphs seeks to justify that change under the banner ensuring fairness in the planning system. And the paragraphs that I shall be inviting you to consider are those that run from 2.2 through to 2.8, right, as being the government's the justification put forward. What then happened was there was a consultation process, including some meetings with representatives of the Gypsy and Traveller community, which are in the papers. Then, in June 2015, the government decided what it wanted to do, and it published the PPTS in the form that's before you, and at the same time, or thereabouts, it updated the public sector equality duty analysis. That's the document at page 180 in the summary, in the supplementary bundle, to which you've had some reference taken. And it also published an equalities statement, which you have at page 191 of the supplementary bundle. And finally, it published a consultation response document, which you have at page 266 and following in the supplementary bundle. And the government returned to the question of its stated proposed policy change at pages 270 to 271, paragraphs 3.6 to 3.7. So if one wants to look for the purported justification under the banner of fairness in the planning system, I suggest that one looks in the consultation document in chapter 2, and one then looks to see what the government's settled policy position in the light of the consultation responses, particularly at paragraphs 3.6 to 3.7 in the response document at page 270 and 271.
Thank you.
I hope that assists Mr. Wilson.
Well, thank you very much, Mr. Mould.
That's very helpful, my Lord. And just looking at the consultation documents, which begins at 205 in the supplementary bundle, my own friend has indicated that paragraph 2.2 to 2.8 is where we should look, and 2.3 perhaps is the nub of the point made in that document. The government feels that, this is at page 2112, where a member of the travelling community has given up travelling permanently for whatever reason and applies for a permanent site, then they should be treated no differently to an application from the settled population, for example, seeking permission for a park home. This would not prevent applications for permanent sites, but would mean that such applications would be considered as any other application for a permanent caravan site would be, i.e. not in the context of PPTS. And then this is not about ethnicity or racial identity, it's simply for planning purposes, the government believes a traveller should be someone who travels. I'm not sure that there's any reference to how that makes the planning system any fairer, but that document predated the public sector equality duty analysis that we were looking at.
The second.
Sorry. Yes, the second one at page 180 that we were just looking at.
Yes, because that was sent under the, as Mr. Moles explained, that was sent under the email of June 2015.
Exactly, 23rd of June.
So just before PPTS 2015, which I think is August.
31st of August.
Yeah. So it's the first one, then the consultation and these documents,
Exactly.
and then the second one attached to the email of the 23rd of June.
My lord, that's right.
Yeah.
So we have the consultation document explaining as it does, insofar as it does, the rationale for the change. What we haven't touched on is the consultation response, which is dated August 2015, and I think may have been published at about the same time, if not the same day as PPTS was published on the 31st of August. Page 270, paragraphs 3.6, 3.7.
Page
270 of the supplementary bundle, my lord.
270.
270, yes. 3.6 and 3.7 at the bottom of the page. And there we have a reference to consultation responses. Firstly, the government notes that the responses from the traveller community and their representatives raise concern about the new definition and its possible impact on their traditional way of life. The government has also noted that the change was supported by the majority of local planning authorities who expressed a view. I don't know how many that is, but those who expressed a view, the majority of those supported it. Many shared the government's view that the new definition would be and seemed to be fairer. This was supported by evidence that the permanent occupation of some sites by some travellers causes resentment amongst the settled community. That, if one can call that evidence, is, in my submission, the high point of the objectivity of the justification advanced by the respondent in this case. Just thinking about that point on a practical, from a practical point of view, it may be obvious, but there is in reality no difference between a gypsy or traveller site that accommodates gypsies and travellers who fall within the definition and therefore continue to travel, perhaps just seasonally, for an economic purpose, but then return with their caravans, park them on stable ground, perhaps a hard standing, use a day room for cooking and washing, and a site which is occupied by gypsies and travellers who have perhaps ceased travelling for an economic purpose in order to educate their children, or perhaps to care for elderly relatives, with the intention of returning to a travelling way of life in the future. They still require a stable or a concrete base for their caravans. They require a day room in order to carry out washing and cooking that they might do. But the same applies to elderly and disabled gypsies and travellers. They will also require the same piece of land, the same stable piece of ground, perhaps, with the benefit of a hard standing on which to put their caravans, the same day room, the same place to park their cars, the same sewage facilities. There is absolutely no difference between a site that accommodates PPTS gypsies and travellers and a site that accommodates non-PPTS gypsies and travellers. And it may be that a PPTS gypsy or traveller who is settled whilst their children go to school may be settled for many, many years. I mean, we know how long schooling can last. For one child, if one has 2 or 3, we could be talking about 14, 16, 18 years. So one just has to look at the, as it were, the evidence, in inverted commas, that the respondent was relying upon for this definition change, to realise that it's really as flimsy as you could. So flimsy that one really ought to have carried out some sort of objective analysis before going down the route of changing the definition. And, you know, this is it, you know, a concern raised by local authorities and perhaps also by individuals about the traditional way of life of Gypsies and Travellers that the government has an obligation to facilitate. So perhaps rather than, and I, you know, let's say it, pandering to possible prejudices and the concerns raised in this consultation exercise, the government could have complied with its obligations under Section 149 of the Equality Act and done something about trying to foster race relations and carried out an exercise whereby they promoted the traditional Gypsy and Traveller way of life, to try and break down those prejudices and concerns that Gypsies and Travellers perhaps had an unfair bias in the planning system. Because we can see from the evidence that was presented to the judge in the court below, accepted by him, that the reality is that there's an endemic problem. The system's going wrong for them. They are disproportionately affected by the planning system. It's more difficult for them to obtain planning permission. And there is a lack of sites in the UK for them to live on. Now, I don't think I've got any other documents within Mr. Gallagher's bundle of exhibits that I need to take you all to. That is the evidence that was before Mr. Justice Pepperall. And
can I just observe, Mr. Willers, in case you want to deal with it, look at the document as you've been speaking. If we look at page 269,
yes. Thank you, Mary.
we see in paragraph 2.1 that there were 771 responses to the consultation,
Yes.
Of which well over half were from members of the traveller community,
Yes.
who might be expected to take, broadly speaking, a particular course in
Yes.
answering questions. Then we see in 2.2 the breakdown of other respondents, various
Yes.
bodies, and we read that in 2.4 many of the councils responding broadly welcome the proposals, but many of the councils responding is many of 10% comprising parish and town councils, 7% comprising local and district,
Yes.
and 4 and 2% county and unitary councils. So in round figures, many of 20% of respondents broadly welcome the proposals.
Yes.
But when we get to Appendix A, which is the Annex A, page 275, which is the summary of the responses,
Yes.
we see that in the first key messages, many respondents agreed that anyone who'd given up travelling permanently should be treated the same as a settled population. Some stated something else, some communicated a different view. Then jumping to question 3, do you consider we should amend? Again, we see many agreed with the need to amend. Some took a different view. And ditto, question 3b, many agreed with the need to amend, but some took a different view. It just strikes me as a bit curious that in a survey in which well over half those who responded were themselves travellers who probably weren't voting to make life harder for themselves, and the body of counsel said to be broadly supportive was about 20% of the response, that the summary of the replies finds that at each point many favour the government proposal and only some put forward a different view. I don't suppose we can take it any further because this report is what it is.
My Lord, we don't have the underlying responses, so there's not been an opportunity to drill down into the figures. Many could mean any number of any number. Many might mean more than a handful. It might mean a considerable proportion of the respondents. But without figures, I mean, if a figure was attached, then it would be so much easier for us to understand quite where the balance, insofar as it was important.
Well, I'm sorry to have carried on interrupting.
No, not at all. But
it's worth pointing it out.
One of the, I suppose, the point feeds into our case really, if I can leave it in this way. That again, it's rather difficult to understand the justification for the definition change without a proper analysis of not just the consultation responses that we can understand, but also a proper analysis of the impacts of the definition change, which one simply does not see in the evidence before the court. It's only focused on the definition change insofar as it relates to gypsies and travellers applying for planning permission who no longer fall within it. And even then it's difficult to fathom. So I'm going to move away from Mr. Gallagher's evidence, unless there's anything else that the audience wanted to address. But can I take you back to the document itself, Planning Policy for Traveller Sites, which we have at page 346 of the core bundle. And we've already looked at the overarching aim, which is at page 349. Noted that it's different from the aim in the circular of 1 of 1994, which was the subject of the Wrexham case.
Sorry, page?
Page 349, my lord. Of the core bundle, sorry.
Oh, I'm sorry.
It's a general point that I make about this policy document, because it is certainly not a document which is focused on transit site provision. There are a couple of mentions, as far as I can see, of transit provision. But by and large, this document is designed to assist local planning authorities in determining planning applications for permanent sites and also to plan for permanent site provision. So it has two features. Plan making is set out, the guidance is set out at page 351 under policy B, planning for traveller sites. And then decision taking the guidance begins at page 354. And I may be corrected if I'm wrong, but the two places where I've seen reference to transit site provision are paragraph 9, where local planning authorities are told they should set pitch targets for gypsies and travellers as defined in Annex 1, and plot targets for travelling show people as again defined in Annex 1, which address the likely permanent and transit site accommodation needs of travellers in their area, working collaboratively with other local authorities. And then, again in paragraph 28, page 356, one can see that local authorities are encouraged to consider, as indeed they should do, how they can overcome planning objections to particular proposals using planning conditions or planning obligations, including, and then the last of the 3 points, limiting the maximum number of days for which caravans might be permitted to stay on a transit site. But if one looks at the rest of the policy document,
So I'm very sorry, Mr. Willis. Are we still under ground 3 and the legitimate aim?
we are.
I'm sure it's
we are.
it's
Lord,
simply
somewhat,
my
no, it's,
note taking. I'm just anxious to ensure I'm under the right heading.
It's a tangential point, my lord. So I understand that you are
Okay.
struggling to see the relevance. But having gone through the legitimate aim and the documents which identify it, I thought I would complete the circle, as it were, by taking you to the PPTS. But perhaps I should just ensure that I...
And why do we mind about transit sites?
Well, I suppose the point is this, that the whole thrust of PPTS is not to facilitate nomadism, but instead to facilitate, is actually more geared towards facilitating the provision of permanent sites for gypsies and travellers.
So you say the policy is at odds with the measure?
Well, what happened is that the measure, the definition has changed, but the policy is still directed towards the provision of permanent sites. And so there is a tension between the two. And we've already looked at the point that there's been, when we were looking at the text of the public sector equality duty analysis, the fact that the policy itself hasn't been adjusted to take account of the definition change, insofar as it does not provide any mitigation for those who may perhaps live with gypsies and travellers who comply with the definition, but in circumstances where they themselves do not. Rather dealing with, as it were, that point. But go back to the finishing off the legitimate aim point, my lord, and back on track. In our skeleton argument, we set out in paragraph 57, which you'll find my lord, at page 86 of the core bundle. The approach that we say that the learned judge in the Coalville should have taken. One reads about 9 lines down from the top. We say that the judge should have determined what was the aim of amending the definition, then decided whether that was a legitimate aim, whether it was sufficient to justify the limitation of the right, and whether the measure was rationally connected to that aim, and whether a less intrusive measure could have been used, and whether a fair balance had been struck. And having not identified the aim, or the measure, and not assessed whether or not not then having properly assessed whether or not the aim was legitimate. Those flaws completely undermine the learned judge's subsequent assessment of whether or not the measure was justified. Now, the learned judge relied to some extent, as did my learned friend, on the case of Wrexham. And in paragraph 58, we make points which I summarised this morning about that decision. It's certainly right to say that that decision is binding on this court insofar as it addresses Circular 1 of 1994. The Court of Appeal's judgment in Wrexham is authority for the proposition that a policy which does not include and has never included formerly nomadic gypsies and travellers will not breach Article 8 of the European Convention on Human Rights. We reserve any point we might make about the decision should this matter go further. But we accept it binding on this court.
So can you be, I'm sorry to ask you to be more precise if you can. To what degree is it binding, do you accept?
Oh, forgive me. Yes, binding in this respect, that as far as Circular 1 of 1994 is concerned, a policy which had as its aim or main intention the facilitation of nomadism, but a definition which excluded gypsies and travellers who no longer practiced nomadism, then it's authority for the proposition that such a policy with such a definition would not breach Article 8 of the European Convention on Human Rights. However, as we say in paragraph 58 of our skeleton argument, page 87, it's certainly not authority for the proposition that amending the policy definition of gypsies and travellers, as was done in 2015, so as to remove formerly nomadic gypsies and travellers who can no longer travel due to age or disability, is justified discrimination under Articles 8 taken together with Article 14 of the Convention, or indeed justified discrimination under Section 19 of the Equality Act 2010. We're dealing with the respondent's decision to amend a different policy with different aims in a way which the respondent accepts was discriminatory, and the question of whether or not that discrimination was justified. And what we say is that if the learned judge in the court below had undertaken the correct exercise, he would have concluded that the measure was not justified.
Sorry, go on.
Sorry.
Well, I was just going to ask two things, or one thing really. Perhaps it's two. In Wrexham, what concession, if any, was made as to discrimination? None.
There was none.
None. In Wrexham, as a matter of fact, there was not a reversion to a previous policy or a change of an existing policy. There was the introduction of a new policy. And
my
the
Lord,
point
that's
that's
right.
stressed
Yes.
in 58 of your skeleton argument is that it's quite different when you've got a policy and then you change it, because it has effects on those who've had entitlements under the policy.
Yes.
Which isn't so if you simply introduce a new policy.
My lord, that's right. I mean, the striking example is the one where a gypsy or traveller who's done nothing to warrant it is suddenly met with the possibility of being evicted or subject to enforcement action.
Sorry, forgive me. That's all clear. It's not open to you in this court to argue that the ratio decidendi, the basis for the decision in Wrexham, was wrong.
No.
That would be available to you in front of the Supreme Court.
Exactly.
But it is your submission, is it, to us that you would wish to reserve that submission?
My lord, yes. It's our submission that Lord Justice Sullivan, without addressing discrimination and Article 14, or indeed he couldn't deal with it under the Equality Act 2010 because the decision predated it, but had exactly the right idea that the definition itself that the Court of Appeal was dealing with at that point in time did not pay sufficient respect to the traditional way of life of gypsies and travellers, an integral part of which involves living in caravans.
And that the Court of Appeal was accordingly wrong for the reasons it gave to reverse his decision.
Yes. But as your lordships noted, that isn't a point that we can argue before your lordship.
Although you're unlikely ever to get to that point, aren't you? Because you say Wrexham may be wrong, you accept we can't come to a different view, but you say none of that matters because it's irrelevant.
That's true.
Because it's dealing with different points, different policies, different words, all of that.
Yes.
So effectively, it's only if we're against you on that and decide that Wrexham effectively is the answer,
yes,
that it would then become material.
Exactly, my lord. Yes, we with respect to the lordships in the Wrexham case, submit that decision is front and centre based upon their analysis of Circular 1 of 1994. It's a historical decision, but should play no part in your lordship's.
Yes, that's the point. You say it's a historical decision which should play no part in our approach to the present case.
And I'll say no more about Lord Justice Sullivan's view at first instance. But
Mr. Justice Sullivan, as he then was.
Yes.
Yeah, understood.
Sorry.
You did maybe exactly the same.
Okay. So we were actually on the same. We were having the same thought.
Thank you.
Right. Thank you.
The point that I was making, as it were, off the cuff, but actually we address in paragraph 60. So I'll just draw your lordship's attention to it. And paragraph 61 is about the learned judge's view expressed in paragraph 80 of his judgment. That the first respondent was plainly justified in drawing a distinction between the specific land use needs of those seeking to lead a nomadic lifestyle and those seeking a more settled existence, and that the former, specific land use needs of those seeking to lead a nomadic lifestyle, throws up particular challenges for the applicants and planning authorities, and that the Secretary of State was entitled to devise a specific policy focusing on that issue, which did not also seek to address the cultural needs of those gypsies and travellers now seeking a permanent home. Now, the point we make in paragraph 61 is that the respondent hasn't produced any evidence to demonstrate any material difference between the specific land use needs of nomadic gypsies and travellers and those of gypsies and travellers who, through age or disability, no longer travel for an economic purpose. And nor could he so, and for the reasons that I've given. A gypsy or traveller site, whether it be occupied by nomadic, semi-nomadic, or permanently settled gypsies and travellers, is likely to look exactly the same from the outside in, and indeed consist of perhaps members of a family who may be travelling, may not be travelling for reasons of education of their children, or may have ceased travelling altogether. but one will still need the basic essential elements of a gypsy or traveller site, no matter whether or not they comply with the definition. Finally, my Lord, we say in paragraph 62 that in accepting that the legitimate aim was to distinguish between the land use needs of nomadic people and of the settled community, the judge erred by failing to distinguish between the actual objective of the measure and the means by which the objective was to be achieved. The aim, we say, mustn't be confused with the means employed to achieve it, and that point is a point made by Lord Carr in the Brewster case. In this case, the aim identified by the judge, we say, is a tautology. He's taken what the amended definition does and then described it as its aim, which we say is all wrong. My Lord, I'm going to move
Swiftly.
swiftly on, my Lord. Perhaps just before I do so, say this, though, that the learned judge's approach, and indeed his identification of one, or possibly, as we suggest in our skeleton argument, two aims, which one cannot find in the respondent's contemporaneous material, has the effect, or had the effect, of dressing up the respondent's true intentions, ensuring fairness in the planning system without the evidence to show that it was unfair, be biased towards gypsies and travellers, with a cloak of respectability. And in doing so, the learned judge then, by not looking, as he should have done, carefully and with anxious scrutiny at the evidential basis, insofar as there was any, for the aim which is clearly set out in the contemporaneous material. I'll say no more about that. Ground 4, justification, and as my Lord Justice Coulson noted at the beginning of the submissions, ground 3 and 4 are very much interlinked. Yeah. But thinking about the Wrexham case and the different approach, assuming of course that your lordships are against me on whether or not the Court of Appeal in Wrexham's judgment has any relevance or any bearing on your lordship's judgment. It's important to note that there is a different exercise to be undertaken when looking at whether or not there's justification for Article 14 discrimination, as opposed to whether or not there is respect paid by a particular measure in terms of Article 8 rights. Can I take your lordships to the Brewster judgment?
Yes.
And paragraph 48 in particular.
This is Lord Kerr.
Yes, again, it's Lord Kerr. And
Paragraph.
the judgments, yes, 48. It begins at page 307. And the paragraph is at 323. The proper approach is the heading. And here dealing with Article 14.
Sorry, page
323, my lord.
323.
And there at paragraph 48, Carr says, the starting point in the analysis of whether there is objective justification for interference with the claimant's right to property must be the duty of the state to secure her entitlement to equal treatment. Unlike, for instance, the duty under Article 8 of the Convention, which enjoins the state to respect the citizen's right to a private life, etc., Article 14 requires a state that it should ensure that her rights under the Convention are in place unless there is an objective justification for denying them to her. And then at the bottom of the paragraph, that I appreciate perhaps you ought to read through, Lord Carr says, the obligation to secure rights must require a greater level of vigilance on the part of the state authorities than is animated by a duty to have respect for a particular species of right. The duty to secure rights calls for a more proactive role than the requirement to respect rights. So not only do we have very weighty reasons and so forth, but also a more proactive role required of the court when determining whether or not indirect discrimination under Article 14 is justified.
And how does that fit into A, cannot show it to be a proportionate means of achieving a legitimate aim? Are there 3 tests?
Well, I think what it does do is
Public.
and this is not necessarily an answer to your lordship, but what it does do is perhaps underpin my point that Wrexham is not the end, even if you thought it was relevant.
No, well, I understand that, but I, I mean, that's the test in Section 19 of the Equality Act. Quite simple. You say complete code. I'm just wondering whether it's seriously suggested that there are 3 different tests in play.
No,
one for the Article 8 claim, one for the Article 14 claim, one for the Equality Act claim.
I think Lord Carr there is drawing a distinction between Article 8 and Article 14 and simply indicating that one might find that a measure is justified under Article 8 but not under Article 14 because the terminology of the Convention includes the word secure as opposed to respect. We say that the learned judge ought to have looked at I'm going to call them safety valves because that's how they're referred to by Lord Justice Lewison in the Ward case, who ought to have looked at how the measure works in practice and whether or not any safety valves or mitigation that was put forward by way of justification worked in practice rather than in theory. And we've identified the decision in the Nur case, which you'll see referred to.
But isn't that what Lord Justice Lewison was doing in Ward?
Exactly. He was looking at
So
practical.
Nur says you look at the practical effect, but that's what Lord Justice Lewison was doing in Ward anyway.
Exactly, my lord. So they chime those 2 decisions. And we say that that's what should have happened in this case. I've already taken your lordships to the decision in the SC case of the Supreme Court and what Lord Reid said about the manifestly without reasonable foundation approach, the width of discretion and deference. And here we have discrimination, we say, intertwined with race, but certainly on disability and age. Grounds which require very weighty reasons and a lack of any proper assessment on the part of the respondent of the impact that the definition change would have upon gypsies and travellers such as the appellant or indeed anybody else in her or a similar situation. And we say that it beggars belief that the respondent could have concluded that the impact on people such as the appellant was proportionate or reasonably and objectively justified in order to ensure fairness in the planning system. Particularly so when it hasn't even acknowledged in its contemporaneous documentation some of the wider ranging impacts of the definition change. There's no real evidential basis for the decision it took. It's very much based on a perception. My lord, I've addressed the Wrexham case insofar as perhaps I think I need to do so for the purposes of my submissions. My own friend may say more about it, and if you'll forgive me, I'll hold fire and listen to what he has to say about that.
I'm beginning to wonder whether you want to say anything about the decision under challenge, which we haven't visited yet.
I can certainly take the opportunity.
I mean, I do appreciate, of course, the nature of the grounds.
Yes.
But the claim seeks an order to quash the decision, doesn't it?
It does, my lord, and we say, and the decision is at page 358 of the core bundle, that the decision itself, the decision on appeal by an inspector, was tainted by the application of the definition within PPTS, which itself is a definition which we aver is one which is unlawful because it is discriminatory in an indirect way against on a number of bases that we set out in my earlier submissions. And the relief we seek is a quashing order. In terms of what might happen in the event that the order, the decision is quashed, we haven't sought any declaratory relief, but no doubt if your lordships were to quash the decision, your judgment would be, or would include, reasons as to why the decision has been quashed, and those reasons themselves would touch upon the decision you've reached in terms of the grounds that we've argued and the discriminatory impact of the definition.
Does the decision shine any light on the application of policy, right or wrong, you say, as opposed to its interpretation and its unlawfulness, as you contend, as a policy?
Well,
I mean, are you saying that, to help explain
Yes.
what I mean, are you saying that the decision in itself manifests the problem with the policy? Is that how you wish to put it?
well, it's
Or do you say that it's a defective application of what you submit also as a bad policy? Which is a different policy.
I don't suggest that the inspector wrongly applied the policy or the definition. She came to conclusions on the evidence as to whether or not the appellant and her family members were entitled to gypsy status or to come within the definition. And we don't challenge that decision before this court. As I indicated when I took your lordships to Dr. Ruston's evidence, and indeed his paragraph 23, I think it was, his evidence was that in a case of this nature where there is a site which is in the countryside but is not subject to any particular designation, and the positive factors that could be weighed, as it were, in the scales in favour of the grant of planning permission nevertheless did not result in the grant of permission, or indeed even temporary permission, one can see that the definition itself is having has had a negative impact on the appellant and her family's ability to live in accordance with their traditional way of life on a site with the benefit of planning permission. The decision goes a little bit further than that, though, because when it came to consideration of temporary planning permission, and your lordships will see under the heading planning balance at 366, the inspector at paragraph 51 said, "I've considered whether granting a further temporary consent would be appropriate in this instance. However, advice in the planning practice guidance advises that it will be rarely be justifiable to grant a second temporary planning permission. Further permission should normally be granted permanently or refused if there is clear justification for doing so. Since a further temporary consent would relate to the occupation of the site by gypsies and travellers who met the planning definition, it would provide no certainty for Mr. and Mrs. Smith." And that last sentence perhaps it hits a nail on the head, because had the definition not been amended, then the family would have complied with it, that being the definition in the previous PPTS issued in 2012. And that doesn't necessarily mean that the inspector would have granted planning permission. I'm not suggesting that. But it seems more likely that she would have done, because the further grant of temporary permission would have assisted the family, even if just for a temporary period of time.
Right. Thank you.
My lord, can I just check my note?
Of course.
My lord, those are my submissions.
Just one thing, if I may, and it's from me. My lords do not have any further questions for you. The relief sought, can you just isolate
Yes.
what that is and make sure that it is still the relief you seek?
I would have set out in the
Yeah.
original.
138.
Yes.
Can you guide me to it?
The section 7 is a very simple request that the decision dated the 23rd of November 2018 be quashed.
Simply a
Page 141.
yeah, simply a quashing order.
My lord, yes.
No other relief sought.
Certainly no other relief sought on the
No.
form, and we haven't applied to amend or.
No.
Maybe
I just
just
want
our
to,
position.
you're not seeking any declaratory relief.
No, my lord, as I indicated,
Mandatory relief.
that's when I was answering the wrong question. It seems to us that if your lordship were with us, then no doubt the court's judgment would serve that purpose.
Yeah, we are, of course, we must remind ourselves in the realm of section 288,
Yes.
so we're constrained by the statutory provisions.
Yes.
Right, that's very helpful. Thank you very much indeed,
Thank
Mr.
you.
Willis. Thank you. Yes, Mr. Mole.
My lord, I'm going to start, if I may, just by referring to a couple of the authorities in relation to the test to be applied in judging whether the justification that is advanced for the acknowledged indirect discriminatory impact of the revised definition of gypsies and travellers is sufficient to pass lawful muster, as it were.
Yeah.
Thereafter, I'm going to look at the target of the claim. I'll take you to the documentary history. I hope not unnecessarily duplicating references that Mr. Willis has made. Look at the focus then on the response on behalf of the Secretary of State to the argument about the lack of a legitimate aim, ground 3 essentially, and then finally turn to proportionality, the fair balance, and whether the means employed, having regard to the acknowledged indirect discriminatory effects, justify the policy change. I won't complete all of that in the next hour.
No, well, we shall aim to finish no later than 4:30, but nearer perhaps to 4:15.
Very well, I'll bear that in mind. And
So you'll find a convenient time in that quarter of an hour.
certainly, thank you. Maybe then just look at the test. Would I invite you, if you would please, to turn to the authorities bundle and tab 9, which is the Joint Council of Welfare Immigrants decision of this court. This decision and the passage I'm going to draw to your attention is referred to by Mr. Justice Pepperall in his judgment. The reference is judgment paragraph 67, page 23 of the core bundle. And the paragraph in question is paragraph 140 in the judgment of Lord Justice Higginbotham, which is page 235 of the bundle.
Yes.
Perhaps 140 and 141. If I could just invite your lordships to read 140 and 141.
Yes. Yes.
Now that was Lord Justice Higginbotham's drawing together of a fairly extensive analysis of authority that began as far back as page 227 under the heading Ground for Justification in that claim, and which began with Lord Reed's well-known four-stage formulation in Bank Mellat, and was focused particularly on the fourth of Lord Reed's stages, which you see at letter D. It's the balancing of the measure's effects on the rights of the claimants with the importance of its objective and the proportionality balance. So what 140 is doing is saying, this I think is where we get to on the authorities. And the theme that runs through paragraph 140, as you would have seen having read it, is it's not necessarily helpful to try and draw rigid boundaries between cases where one is looking to see whether the measure complained of is manifestly without reasonable foundation, and other cases where the court needs to undertake a more intensive analysis of where on the proportionality analysis the balance lies. What Lord Justice Higginbotham drives at in my submission is the need to avoid drawing rigid boundaries or limitations, but to focus on the factors that inform the proportionality balance in any given case. And amongst those factors will be the strength of protection that is enjoyed by the protected right that is engaged. So, for example, where it is race or sex, the starting point is that is one of the protected rights that enjoys the strongest degree of protection. Looking at the degree to which the measure in question involves a political judgment, a political balance between a variety of socioeconomic factors, for example, in the field of welfare provision, and without putting things into boxes, reaching a considered judgment, essentially by weighing up the question whether the impact of the measure is in proportion to the importance of the aim that it seeks to achieve, as a question of degree. Now, if any of that is unhelpful to you, you'll ignore it because you'll follow the words of Lord Justice Higginbotham, but that's an attempt at least to give some flavour of what I understand to be the approach that he is seeking to do. And what he's clearly seeking to do is to find an approach that is, if not of universal application, at least seeks to provide a consistency of approach across the multiplicity of cases and scenarios in which this kind of issue arises. That is to say, an alleged discriminatory measure and a question whether the proponent of that measure has provided a justification for it. That paragraph, those two paragraphs rather, which Lord Justice Henderson agreed, see page 239, paragraph 156, as indeed did Lord Justice Davis, although he gave his own judgment. You see paragraph 180, where he indicates his agreement with Lord Justice Higginbotham on his reasoning. That paragraph was then referred to by Lord Reid in the SC case, which my learned friend, understandably and rightly, if I may say so, has focused his submissions on.
Do you want us to look at that?
If you would, go back, if you would please, to a passage, the paragraphs that my learned friend drew to your attention earlier, beginning at page 128.
Right.
And
128, yes.
paragraphs 157 all the way through to 162 are to be read and to be read carefully together. I mean, that is, as the subheading on page 128 indicates, conclusions on the manifestly without reasonable foundation approach. That is Lord Reid's own analysis, drawing together his conclusions. And you see that at 161, he endorses the conclusions, essentially endorses the conclusions drawn by Lord Justice Higginbotham in the Joint Council of Welfare Immigrants case. The ordinary approach to proportionality will accord the same margin to the decision maker as the manifestly without reasonable foundation formulation in circumstances where a wide margin is appropriate. But as he has previously indicated in paragraph 159, one has to be flexible in the way one approaches these matters. And the court's approach will be influenced, amongst other things, by the degree of the seriousness of the protected right that is engaged in the given case. I also invite you, I'm sure, rather than invite you to read all those paragraphs again now, I'm sure the court will have read those paragraphs carefully in considering its decision. But over the page at 130 are some salutary words about the need to recognise the principle of separation of powers and to recognise the complementary role of the courts and government and legislators in a field where, as Lord Reid observes, challenges to legislation, and one might infer policy measures as well, on the grounds of discrimination, have become increasingly common in the United Kingdom.
Sorry, where does he say that?
That's at the top of page 130.
Yeah. Yes, sorry, I see it.
And he refers indeed to the favoured ground of challenge being usually Article 14. Yeah. And the risks inherent in the principle of proportionality, which, as he says, confers on the courts a very broad discretionary power, the risk of courts abusing that power and resorting to undue interference in the sphere of political choices. And planning policy, which is designed to meet an identified need for land use provision to serve a particular group of people within the community, is plainly an example of government making a policy choice. Now, in the present case, as we shall see in a moment, the complaint upon which this claim was founded when it was first made in the administrative court was to do with the fact that the application of the revised definition of gypsies and travellers for the purposes of planning policy for travellers' sites 1915, the effect of applying that revised definition to the facts of Smith's case was that she was judged to fall outside the scope of that definition by the planning inspector. The reason for that, essentially, was that she had settled, apparently permanently, on the site to which the planning application related, because of the fact that her adult sons were seriously disabled, and it was therefore not realistic for them to pursue an actively nomadic habit of life, or indeed to contemplate the resumption of such a habit of life at any time in the foreseeable future. So this was not a, if you will, permanently settled by choice case. This was a permanently settled through force of circumstance case. And I certainly don't shrink from seeking to justify the change in the policy definition from its application to a case of this kind. As it happens, it's essentially the same case as was before this court in the Wrexham case, because in that case, if you recall, the claimants who had been denied planning permission on the basis that they fell outside the scope of the then current planning policy definition of gypsies and travellers, the basis for that excluding them and thus denying them planning permission was that they had retired, and on that basis they were they had so permanently ceased to travel. So that in the parlance of modern equalities legislation, their protected characteristic was one of age. In the case of the current claimant, the protected characteristic is disability. But in terms of drawing an analogy between the operative factor, both in Wrexham and in the present case, it is essentially the same. It is the debate before the court in Wrexham and before this court arose because the ethnic gypsy in question, or the ethnic gypsies in question, had ceased to pursue a nomadic habit of life, not through choice, but through force of circumstance. And it was in that context that that Mr. Justice Sullivan, as he then was, as your Lordship observed earlier, expressed the view that common humanity demanded that in the Wrexham case the claimants ought to fall within the scope of the then current definition, and the Court of Appeal, this court, disagreed for the reasons given primarily by Lord Justice Old.
One difference, of course, is that in Wrexham, according to that definition, they never had that right. In this case, in July 2015, they did. In August 2015, it was taken away.
Yes.
And you'll get to it under justification, but speaking for myself, I'd like to see where that deprivation of rights was considered.
Yes.
Because just instinctively, that sounds odd.
Yes.
I had a right one day, the following day I didn't.
I fell within the scope of a target group identified in a planning policy.
Yes, but that meant I had a right to live here. I can't remember how long they've lived there, but I think it's 2012 or something. I had a right to live here, now I don't.
Yes,
Possibly one of the most fundamental human rights.
well, your Lordship has in mind the fact that I think the inspector alluded to in the final paragraph of her decision letter, Mr. Willers showed you a few moments ago.
Yeah.
That what had previously been certain had become uncertain. That is to say, because the planning permission had included a condition which limited the permission to persons who fell within the current definition of gypsy and traveller.
Yeah.
As your Lordship puts it, until under the definition as promulgated in 2012, Mrs. Smith and her family fulfilled that, fell within that definition, and therefore they had the certainty of knowing that they fulfilled the terms of the condition. Following the introduction of the new policy, there was at least uncertainty as to whether they fell within the scope. And indeed, one obvious conclusion from the change in the definition, so as to remove the words "or permanently," was that they no longer fulfilled the condition. In which case, they faced the risk. Whether that risk would have eventuated, of course, is a matter of speculation. They faced the risk that, given that they were, in legal terms, in breach of condition in their occupation, of enforcement action being taken to require them to remedy that breach. Now, whether the local authority in those circumstances would have thought it appropriate to take enforcement action to remedy that breach, of course, is a matter for speculation. But it doesn't detract from the point that it replaced certainty with uncertainty.
I understand that, but of course, if you have a policy which you want to enact, you do that because you want it to have particular effects. You don't create a policy and then say, well, it's up to other people as to whether or not it's enforced.
No, but you do. If you're promoting a policy which is designed to inform decision taking in the planning sphere, you do so in the knowledge that the policy will take effect as a material consideration in the determination of a planning application.
Yes.
But it will sit alongside the multitude of other material considerations that will inform a decision in a given case, and you will know that the decision maker will evaluate those considerations, including the policy, in order to arrive ultimately at a decision whether or not planning permission should be granted.
Yes.
And the same applies to an enforcement case.
We'll get to it under justification, but it's that I'm particularly interested to see what the consideration was about people who fell within and then fell outside.
What I can say, I had in mind to reflect on that point, and it will come logically later in my submissions. But,
of course.
But my Lord, I think what I can say, in the light of my consideration of having reflected on the contemporary documents, it wasn't an intended consequence of the policy change, but I will need to grapple with the question whether it nevertheless was an unintended consequence, and the court may want to consider whether it was an unintended consequence that the policymaker ought to have considered.
Sorry, what exactly was not an intended consequence?
That the change of policy should replace the certainty of knowledge that that an occupier of a permitted caravan site, subject to a condition that the occupation should be by those who fulfil the policy definition of gypsies and travellers, that such persons should lose the certainty of knowing that they met that definition and thus were able to rely on the planning permission. The focus of the policy change, as I read the documents, was on the determination of planning applications, rather than to interfere with the operation of existing permissions. But I don't resile from the point that is made that on analysis, if you have a planning permission, as there were undoubtedly, as in the present case, there would have been a number across the country granted for caravan sites to be occupied by condition by those who fulfilled the criteria, the definition of gypsy and traveller. But if you narrow the definition, you run the risk that you thus create the uncertainty that I've just identified.
Well, there could be, I suppose, a condition in a particular case that stipulated that the occupation should be in accordance with government policy for the time being related to traveller sites, gypsy and traveller sites. Then the permission would be to that degree subordinated to any fluctuation in policy.
It would.
And the policy doesn't explicitly attend to that situation, does it?
No. There is nothing in PPTS 15 that specifically addresses this issue.
I mean, clearly in another case where the condition said by a person who is a gypsy or traveller, or within the definition of a gypsy or traveller in the Act, then that would be different, because that would steer around the policy. The policy wouldn't have any bearing on the operation of the condition and the planning permission.
And indeed, if the condition said, occupation limited to those persons who fulfil the definition of gypsy and traveller in Circular 1 of 2006.
Yes, exactly.
The risk that I think the uncertainty that my lord court has identified is in that category of lordship as isolated out, which is where the condition is expressed by reference to a class of persons whose members may change, and in particular may narrow as a result of changes in the policy definition itself. And that's the concern I think that Mr. Willis is expressing in the present case.
I mean, it may not be for now, it may be for reflection overnight, but the logical next question would be, well, suppose we found that, we isolated that as a matter of unlawfulness in the policy, however that concept was formulated. But the government took the view that it would wish to change the policy to attend to that situation, because it wasn't intended. And the consequences of that might need to be considered, whether there's anything that could be done about it within the frame of these proceedings.
Well, it's to that I was going to turn next, actually, because it certainly might, one way in which, if this court were to make a finding to that effect, one can imagine that the government's reaction might be that it would amend the policy to indicate that the policy definition was confined to those to planning applications, the determination of planning applications, which after the date on which the policy, as amended on this scenario, was brought into force. In other words, to make it clear that the narrow definition should not apply to the management and regulation of existing permissions, where rights of occupation were constrained by conditions by reference to an earlier, to as your lordship put it, a definition of gypsies and travellers for the time being.
Yes. Well, that's a matter perhaps on which you may wish to reflect, even to take instruction provisionally at least.
I shall do so, I think. Yeah. Lord, may I then just return to the target of the claim?
Sorry, you've taken us to the test. Is this effectively under the heading of ground one? I mean, you've shown us SC and JCW. Are you going to come on to deal with that, or is that effectively the answer?
Well,
sorry to be boring, and I think it's just so that I get my notes in the right sequence.
It is effectively the answer. I mean, my understanding of my submission as to what the judge was doing in relation, by reference to the Christian Institute case, is he was founding upon the way, as we shall see in a moment, the claim was actually pleaded. because the claim speaks, as we shall see, of the policy being inherently unlawful. So the judge saw this, and there was a clear element in the claim which was seeking to say this policy was simply bad, and it couldn't be applied lawfully. And therefore, there was some force in the argument that the relevant question was whether it was capable of operating in any case in a lawful way. But actually, in the present case, we're dealing with a Section 288 challenge. And so the focus ultimately has to be on whether the decision which is before the court under that challenge is or is not a lawful decision. Or in other words, is it amenable to review within the scope of the conventional approach to review under Section 288? And it follows that one is ultimately looking to see whether the decision that is before the court, that is to say the inspector's decision to refuse planning permission, whether that decision was infected, as Mr. Willeth puts it, by the application of a policy which on analysis has legal flaws. Because it would be a conventional approach to judicial review of a decision under 288 for the court to intervene on that basis.
So I understand that, but just so that I'm clear on the overall approach, the judge said in relation to the need to justify, I think in particular in relation to disability discrimination, he said, and he referred to the cases, and he said very weighty reasons would be needed.
Yes.
Do you agree with that?
That is, yes, because that is well, I agree with that as a paraphrase, a summary, a paraphrase and a summary of the approach that is identified by Lord Justice Higginbotham in JCWI and later by Lord Reid in SC. In other words, where, as in this case, the policy maker acknowledges that the policy does give rise to indirect discriminatory effects, it is for the policy maker to justify the policy as having a legitimate aim and to justify the means employed through the policy of meeting that aim as being in proportion to the effects that it has on those who are the victims of its indirect discrimination. My argument is that the judge, whatever he may have said about Christian Institute, he approached the matter in that way because he did apply what Lord Reid said in Bank Mellat, the four-stage approach, as you'll have seen from his judgment. But in a sense, it doesn't much matter because, as Mr. Willers has said, if this court is troubled by the judge having referred to Christian Institute, then this court has the material before it which enables it to reach its own judgment. And so really the operative grounds of challenge in this case are essentially grounds 3 and 4.
Well, that was going to be my follow-up, so I understand that completely.
Yes, and certainly as you will appreciate, in my skeleton argument, I've sought to provide a response to each of the 4 grounds. But I hope it was clear to the court from reading my skeleton argument that the emphasis of my response was in relation to grounds 3 and 4.
Yes. And so you're coming on to the target.
Yes.
And will that, I'm just trying to see, again, pedantically from my notes, where ground 2 fits in.
Well, this is really dealing with ground 2.
Excellent.
Yes. And it's rather important in my submission for reasons I hope I'll be able to make good. The starting point is obviously uncontroversial. One needs to identify carefully the measure that is said to give rise to the unjustified and disproportionate discriminatory effect. In this case, that is the definition in Annex 1 to PPTS 15, which is at page 357. You've been shown that. Page 357 in the core bundle. And that effectively identifies the target group of persons whom the policy, the land use policy, which is promulgated in PPTS 15, is designed to benefit in both plan making and decision taking. How then is the claim put in relation to that definition, that measure? We turn to the claim form, beginning at page 138. As we've seen, page 139, it's a section 288 claim. The target of the challenge is the decision of the inspector. Page 140, the question is posed in the middle of the page: does it include any issues arising from the Human Rights Act? The answer is given yes, Article 8. Then section 7 on page 141, the relief sought, as my Lord Justice Lindblom has identified, is quashing of the decision. The grounds begin at page 144, and the sole ground that is before this court is that which is set out on page 150 under the heading under ground 2. The claimant's adult sons, Isaac and Tony Smith, are severely disabled, cannot travel for work. Given that fact, it is clear that they cannot comply with the planning policy definition of PPTS 2015, and they are not entitled to gypsy status. However, the planning policy definition in PPTS 15 is inherently unlawful in that it discriminates against the elderly and disabled members of the gypsy and traveller communities by denying them gypsy status in circumstances where they are unable to travel to work on grounds of old age and ill health. As such, the planning policy definition in PPTS 15 offends not only Section 19 of the Equality Act, but also constitutes an unjustified interference with the human rights of Isaac and Tony Smith, protected by Articles 8 and 14 of the Convention. It follows that the inspector's conclusion that Isaac and Tony Smith were not entitled to gypsy status was tainted by the unlawful planning policy definition, and that it should be quashed. So that was the basis for the claim. And harking back to the alternative ways in which the claim was put against the decision letter that my Lord raised with Mr. Willers a few moments ago, it's clear from that it was not being said that the inspector had done something wrong in her application of PPTS 15. It was being said that she had essentially applied that policy perfectly properly, but the policy itself, by virtue of the narrowed definition of gypsies and travellers, in the way that is there set out, operated unlawfully in a discriminatory and unjustified way in this case. And your lordships will see that the claim is firmly rooted in that respect in the personal circumstances of the claimant's adult sons. The fact that through force of circumstance rather than choice, they were unable to travel as nomads, and that in excluding from the target group of PPTS 15 those who through disability or old age were no longer able to travel, the policy operates in a way that is unjustifiable and discriminatory and disproportionate to its aims. Now, the inspector did indeed found her decision in relation to gypsy status on essentially that basis. The relevant paragraphs of the decision letter are paragraphs 33 to 39, which you have at pages 363 and 364 in the core bundle. I'm not going to read them out. You will have read them. But the grounds of claim that I've just drawn to your attention accurately encapsulate the inspector's rationale in her determination of gypsy status so far as the two adult sons are concerned. It is also pertinent to note, as we are focusing ultimately on a decision made in the context of, amongst other things, the policy promulgated in 2015, that the inspector did indeed go on to consider the personal circumstances of the claimant and her family. See paragraphs 40 to 43 on page 365. She decided that at 43, final sentence, that the presence of children, the disabled adults, and the family group as a whole, that their best interests would not be served by being required to move from the site, and that those considerations carried significant weight in favour of the grant of planning permission. And she also went on, when she drew the overall planning balance, see page 366 and 367, to address the rights of the family under Article 8 of the Convention, to treat the rights of the children, the interests of the children, as a primary consideration, paragraph 47, to draw the Article 8 balance, paragraph 48, and to fulfil her duty under the Equality Act, section 149, at paragraph 49. No complaint is made about the propriety of her assessment on any of those points. That is to say, her consideration and evaluation of personal circumstances, convention rights, the rights of the child, and the Equality Act. In this case, notwithstanding the weight she gave to those matters, she concluded that the environmental impacts that she had found, which were adverse to the grant of planning permission, should prevail, both in terms of the grant of a permanent permission and in terms of the grant of a temporary permission. But there is no doubt that one of the considerations that operated on that balance was her conclusion, which in itself is not impugned, that applying the policy definition Gypsies and Travellers in Annex 1 to the 2015 policy statement, that these claimants were not, that these applicants rather, did not fall within the definition, and therefore that the policies set out in PPTS 15 should not apply to her consideration of this case.
Well, was that truly the decisive consideration? If you look at the planning balance.
It wasn't the decisive consideration, but it was an operative consideration.
Well, when I say decisive, I mean, is there any way that one could sensibly read those paragraphs and conclude that she would, but for that definition, have reached
a different
conclusion, different ultimate conclusion?
It is difficult to see how she might have done so, because the factors that outweighed, because having drawn together those factors that weighed in favour of permission, it is difficult to see how a difference of status would have caused her to reach the different view. She was clearly impressed by the adverse environmental effects and the policy objections to the proposal.
So you're submitting at least that there's a real possibility that she would in any event have dismissed the appeal.
That isn't a point, of course, that has been considered hitherto in this case. It wasn't a point that the judge addressed. But what I do invite the court to draw from the way in which the claim is pleaded and the way in which the matter was decided is that this is not a claim, a wider claim about the impact of the revised policy definition on the land use needs and prospects in the planning, in the development control context of Romany gypsies and Irish travellers generally. Thus, for example, this claim does not in any shape or form engage or relate to a case in which someone who is within the ethnic group, a Romany gypsy or an Irish traveller, by choice decides to cease permanently from active nomadic habit of life and to settle permanently. And I invite the court, with the greatest of care, with respect, to avoid allowing the debate in this claim and its judgment to stray beyond the carefully drawn confines of the ground with which the court is seized, in paragraphs 24 to 28 of the claim form. We are here concerned with a very defined group of persons in the case itself. And within the context of the definition, a group of persons who would, on the face of it, have fallen within the scope of the policy definition in 2012, but fall outside the scope of that definition in 2015 by virtue of the removal of the words "or permanently."
Which explains why this is not, forgive my Latin, an ab ante challenge. Because, as you rightly say, it's concerned with a very defined group of persons.
Yeah. Well, it's certainly, insofar as it is anticipatory at all, and I'm not going to seek to argue against the proposition your lordship should put to me, but insofar as it might be said to be anticipatory, it is confined to that group of ethnic Romany gypsies, because we are dealing here, Mrs. Smith and her family were Romany gypsies, not Irish travellers. Ethnic Romany gypsies, of such a family of whom some or all of its members, either by virtue of age or disability, or indeed educational need, were by force of circumstance on those grounds alone, if effectively unable any longer to travel nomadically, even had they wished to do so.
Yeah.
And it has never been the case, in my submission, that planning policy has sought to make special provision for gypsies and travellers purely on the grounds of ethnicity. The central focus and the central basis throughout, both in terms of legal definition in the 1968 Act, and then since its repeal in section 24, subsection 8 of the 1960 Act, the policy definition in Circular 1 of 94, in Circular 1 of 2006, in 2012 and in 2015, has been rooted in the concept of nomadic habit of life. It is a functional definition, it is not a racial definition.
It's not a
Racial or an ethnic definition. It is to do with people, it's a providing for the land use needs of people who, in functional terms, travel nomadically. That is to say, not only for play, but also for work. What happened, the courts, I'm laying this out now, I can come back to this tomorrow and provide you with a little more of the authority. What happened and what was noticed in Wrexham was that the courts had interpreted the statutory definition, which referred to persons of nomadic habit of life, as extending not only to those who were actively nomadic, but also to those who had ceased for a period to pursue an actively nomadic habit of life, but who, on the facts, were clearly it was rightly to be concluded they would resume it at a later stage. There was a case called Greenwich and Powell in the House of Lords in which that issue arose. And so the definition that was employed in 1994, in the circular you saw earlier, although that circular was rooted in the statutory language, it was to be understood as embracing not only those who were actively nomadic, but also those who had ceased temporarily to be actively nomadic, but who, on the facts, one could find would resume that habit of life. That definition was then extended in 2006, as you saw earlier. It was extended to make explicit what was implicit, but also to extend further to include those who had ceased to travel permanently through force of circumstance rather than through choice. Remember that the reference was made to, for your notes, this was in tab 25 of the authorities bundle. The definition was at page 727. Reference was made to persons of nomadic habit of life, whatever their race or origin. That's the statutory definition, including such persons who, on grounds only of their own or their families or dependents' educational or health needs or old age, have ceased to travel temporarily. That would fall within the scope of the statutory definition as interpreted by case law and noticed by this court in the Wrexham case, and then extended further by the words "or permanently" to embrace those who had ceased to travel, ceased to pursue a nomadic habit of life, but for particular reasons. That is to say, on grounds only of their own or their families or dependents' educational health needs or old age. So the focus of the extension to permanent cessation was very much confined to those who had done so through force of circumstance rather than through choice. That was then carried through, as Mr. Willers showed you. If you turn back to page 721, that extended policy definition was carried through to PPTS 2012.
731, is it?
721.
721, sorry.
So you can see that at the top of page 721, essentially the same formulation as we saw in the definition of Gypsies and Travellers in the 2006 circular. And you can see the words "or permanently" remain in the definition. And then if you turn, if you recall, in linguistic terms, the change that has occurred between 2012 and 2015 is to remove the words "or permanently." And so, as you have the 2012 definition in front of you, you can just read that and read out, as it were, the words "or permanently." You can see the extent of the change, and that is the focus of this claim. No wider than that.
You say it's a very narrow focus.
Very narrow focus. Yeah. And it would be, if one harks back to the salutary warning of Lord Reid in the SC case,
Yeah.
because challenges of this kind are increasingly common, because they raise the opportunity of the court's function in making a judgment about proportionality, but the risk that opportunity carries of undue interference with political judgments, it is vital that in these cases the focus of the court's inquiry, in my submission, is limited precisely to the four corners of the challenge that is placed before the court and does not range more widely. There may be another case next week in which a much wider focus falls to be considered. But that is not this case. And so appeals...
You say that because you've shown us the claim, and you say that the policies are always about travelling, and that gets extended and then more recently narrowed.
Yes.
But you say that's all about travelling.
Yes. Nomadic habit of life.
Yes. Isn't the artificiality of that being a gypsy is an ethnicity?
Well, that may be so.
That's why we have a separate policy.
Well,
that's why there is a separate policy. That's why the inspector has a section, gypsy status of the current occupiers.
Gypsy status of the current occupiers for the purpose of determining whether the applicants in that case and their families fell within or without the stated policy, not on a broader front. The question in any given case, as in this case, the broader question as to whether there are ethnic and cultural imperatives that ought to weigh in the planning balance in favour of a grant of permission, even though the applicant does not fulfil the planning policy definition, that question is in principle always engaged in a case involving an ethnic gypsy or an ethnic Irish traveller, because that is that being the effect of the positive obligation identified by the European Court in Chapman. It also arises because of Section 149 of the Equality Act, which sits entirely free from the issue, the argument about the policy definition in this case. Whatever the policy definition said, any case which involved a planning application brought on behalf of or in favour of an ethnic gypsy or Irish traveller would involve someone who had a protected characteristic, and therefore the decision maker would have to fulfil the Section 149 duty in determining that case. Any case that involved a potential adverse impact on a child of such a person, any decision on a planning application or an enforcement case, would have to take account of the best interests of the child. See Collins. Any case of that kind would have to consider the personal circumstances of those affected by an adverse permission. See Mr. Justice Ousley in Basildon. So the definition, the narrowing of the target group affects the ability of such a claim, an applicant, to take the benefit of the policy which is set out in PPTS 2015. But it extends no further than that. That person can say to the decision maker, I may not fall within the target group, and on that basis, I can't invoke policies within the PPTS. But my personal needs, my cultural needs, my racial needs, or needs that arise from my ethnicity, and the interests of my children, elderly people in my family, disabled people in my family, all of those matters should carry significant weight in the decision. Because if they don't, if they're not given appropriate weight, the decision maker will be in error of law under, as the case may be, Section 149, under the Human Rights Act, because they've acted in breach of they failed to fulfil the Chapman positive duty, etc.
So take this putative case, different circumstances from the present case. A Romany gypsy who is out with the terms of the policy, doesn't have the benefit of the policy, as you put it, I think. Application for a site, for the siting of a caravan, or a park home, if that's the right description, in the greenbelt, perhaps in the countryside, therefore, and perhaps in an area of protected landscape. So if you like, the planning cards would be stacked against what I'll call the applicant who doesn't have that ethnicity and those circumstances. There would be the policy, the reality of the law, you say, is that there would have to be a different approach to that application for planning permission if made by a Romany gypsy. That would be planning is normally, as it were, I'll put it this way, blind to the personal circumstances of the applicant, because it's about the use and development of land in the public interest, not in the private interest. But where those characteristics exist, and one could frame other examples, then that applicant will, under the law, have a different approach adopted to their application for planning permission than if they did not have those characteristics.
That's correct. That's correct.
Sorry, if I may, just irrespective of the policy,
exactly.
Because that person is outside the policy.
Exactly.
So, understanding that, and as you say gypsy status of the current occupiers, that heading is to do with policy. So where does the inspector deal with ethnicity?
She deals with it in, just bear with me. She looks at paragraph 43 on page 365. I just invite you to read that paragraph. The GTAA is a reference to the Gypsy and Traveller assessment, identifying a need for six pitches for gypsies and travellers who do not meet the planning definition. There's no specific provision in the local plan for such pitches, and no sites are currently available to this family. This is under the heading of
it perhaps raises a slightly wider question, Mr. Mould, in view of what you've just been submitting to us, as to whether it may be thought surprising that if all these matters are still to be taken into account, the evidence suggests that the assessed need for provision of sites for ethnic gypsies was reduced by somewhere between half and two-thirds.
Yes.
Following the introduction of the definition.
Well,
speaking for myself, I find it a bit difficult to understand why that is so. If your core submission is that really it shouldn't make all that much difference, it just means the applicant will have to take a longer route and not be able to take advantage of the relaxed regime.
Well, I'm conscious of the time. But my submission, my core submission, is that the justification for for the narrowing of the policy definition, and therefore the narrowing of the operation of PPTS, special regime under the policy regime under PPTS, that justification has to be considered against the broader framework of the development control system and what is material to the determination of any given case. Now, and indeed, as your lordship's really is focusing on the plan-making function rather than the decision-taking function. But the same submission applies in relation to the plan-making function. What I cannot assist you with is why something that was explicitly, you'll see in the document tomorrow, something that was clearly foreshadowed that provision would need to be made through planning, through that alternative route, essentially as part of the forward planning to meet the full range of housing needs, including those of settled gypsies. Why that has not so far succeeded in fulfilling that, and you may recall in the judgment, Mr. Justice Pepperall asked me that question, and I offered what seemed to me to be plausible reasons why that was so. But
I think was the judge's epithet.
Thoughtful, yeah. Well, I'm glad to have been thoughtful rather than thoughtless.
In the judicial lexicon, that's on the good side.
Thank you.
High up the good side.
Well, that's good to at least be able to mark that one against my card. It's not my purpose today, on behalf of the Secretary of State, to argue that the system is operating seamlessly well. I mean, that would be a wholly unrealistic attempt in the face of the evidence that you've received. And the problem is described by the judge an endemic. I'm not here to produce evidence to seek to quarrel with that. But what I am here to do is to seek to explain to this court the context in which this policy change needs to be understood. Because unless the court understands that, the court can't make a properly balanced and considered judgment of the proportionality of the court can't draw the proportionality balance in a properly informed way. Where the court draws it, in a sense, I have nothing to say about, because that is a matter for the court. But I hope I can assist you with the matters that go into the balance, and that is what I'm seeking to do. But I know I'm overstaying my welcome this evening. Can I just complete my answer to my Lord Justice Coulson? If you turn to page 366, you will also see
49.
reference to paragraph 49.
Yes, I'm sorry, I have noted that. So your answer to my question is 43 and 49.
Yes, I mean,
So that's where ethnicity
yes.
is addressed.
I mean, 47 to 49, if you like, read as a whole, because in those paragraphs, the inspector is dealing with Article 8 as well as the equality duty. And it would be applying conventional principles of judicial review of planning appeal decisions. My Lord Justice Lindblom will readily understand. The inspector didn't need explicitly to reference the positive obligation arising from Chapman in paragraph 47 and 48. She's to be taken to have had in her mind that Chapman imposes a positive duty, because that is a very well established feature of the development control system in relation to Gypsy and Traveller applications, whether they be from those who fulfil the planning definition or those who, although they don't fulfil that definition, nevertheless are ethnic gypsies. Mr. Willers showed you the paragraphs, I think it was 73 and 96 in the Chapman case, which established that proposition.
Right.
Lord,
very well. We've just strayed a little beyond
yes.
4:30, so we're going to stop now and resume at 10:30 in the morning. And the indication you gave earlier holds good.
Yes.
That we shall finish comfortably in the morning.
Yes.
Good. Well, thank you all very much. 10:30 in the morning.